Good morning, friends. Today I am going to solve question 2 of the Advocate on Record of 2023. This is from paper 1, question number 2. Firstly, I am reading out what the question is. Which are the statutes under which the Supreme Court exercises appellate jurisdiction, whether the scope of jurisdiction of the Supreme Court at statutory appellate body is different from the jurisdiction exercised under Article 136 of the Constitution. So this is the question. Going to answer this. The Supreme Court of India exercises appellate jurisdiction under various statutes. These statutory provisions delineate the circumstances under which the Supreme Court hears appeals from lower courts and tribunals. The scope of appellate jurisdiction under statutory provisions differ from the discretionary power of the Supreme Court under Article 136 of the Indian Constitution. Now I am explaining in detail. Statutes providing for appellate jurisdiction. First one, we can say this is Civil Procedure Code 1908. If we see section 109 read with order 45, then appeals lie to the Supreme Court in civil matters involving substantial question of law of general importance. Then comes the Criminal Procedure Code 1973. Section 374, subclause 4. Appeal lies in cases of death penalty confirmation. Section 379. Appeal against acquittal or conviction in cases involving the interpretation of the Constitution. Now, the provisions which are available in the Constitution of India itself, these are Article 132 to 134. Article 132, Appeal in Constitutional Matters. Article 123, Appeal in Civil Cases. Article 134, Appeal in Criminal Cases. Then comes Arbitration and Conciliation Act 1969. Section 37, Appeal against orders related to arbitration matters. Then comes Special Leave Appeals under Taxation and Company Law. That is Income Tax Act 1961, appeals from Section 261. Then comes Companies Act 2013, appeals from Section 423. Election laws. Then comes Representation of People's Act 1971, appeals in dispute regarding elections. Statutory tribunals, appellate jurisdiction over decision from tribunals such as National Green Tribunal, Armed Forces Tribunal, and Security Appellate Tribunal, among others. Now, let me compare Article 136 with statutory appellate jurisdiction. Article 136 provides discretionary power to grant special leave to appeal, applicable across all cases, including constitutional, civil, criminal, and other matters. The court is not bound by statutory limitations and may intervene to prevent gross injustice. Article 136 is not an appellate jurisdiction per se, but a residuary power. Now, statutory appellate jurisdiction. It is derived from specific statutory provisions. The scope of review is limited to the provisions of the concerned statute. The Supreme Court acts as a regular appellate court when hearing appeals under the statutes. The jurisdiction is not discretionary but governed by the framework set by the law. So the key differences are, first one is, if we go by nature, then statutory appellate jurisdiction, it is mandatory when statutory conditions are met. Under Article 136, discretionary and extraordinary. If we go by the source of power, then first one is from specific statutes and second one is from Constitution Article 136. Scope, it is limited by the statute, and as far as Article 136 is concerned, it is broad and unfettered. Objective, regular appellate review, and under Article 136, it is correction of grave injustice. So I am concluding my answer. While the Supreme Court's statutory appellate jurisdiction is constrained by relevant legislative framework, Article 136 empowers the court with wide discretion to act as guardian of justice, irrespective of statutory constraints. This distinction ensures a balance between structured appellate mechanism and extraordinary constitutional remedies. This is all about, and now I am nothing more to say in this answer. So, lot of thanks for seeing this video. God bless.